please the court.
Yes.
Counsel. Ladies and gentlemen, I want to begin by thanking you very much for your service. It's been 3 long weeks, and I want you to know that everyone is very appreciative of the time and attention you've given this case. No greater responsibility for a lawyer is trying to save his client's life. And as I said in my opening statement, I respect, the defense respects your verdict. We're not here to discuss or dispute the evidence in the case that led to your decision, your verdict of guilty in this case. But I suggest to you, and I believe that sufficient evidence has been presented to you to make it clear that a life sentence is the correct sentence in this case, that death penalty is not appropriate in this particular case. Now, before we get into what was presented during the course of this penalty phase, and keep in mind the judge is going to read you another set of laws that you are to follow in your deliberations. But I think it's important to touch on these points again that were discussed early in this case during jury selection. As has been stated already, the aggravating factors or mitigating or aggravating circumstances must be proven beyond a reasonable doubt. However, any mitigating circumstances or factors only need to be proven by the greater weight of the evidence, or more likely than not. That you're being asked when you go back and deliberate to basically decide whether the aggravating factors outweigh the mitigating factors or vice versa. However, it's important to keep in mind that under no circumstances must you vote for death. You must consider all the circumstances that have been presented and decide whether they've been proven by the standard that the law provides. But you are not required in any respect to vote for death. That is a personal decision that you each have to make. And obviously, I know that you will make it with a lot of thought and consideration. Also, unlike the aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established by the greater weight of the evidence. Whether a mitigating circumstance has been established is an individual decision that each of you would make as a juror. And also that every juror has the legal authority to give the weight of life to any one mitigating factor or circumstance that is established. I submit to you that the mitigating factors in this case outweigh the aggravators that the state is suggesting to you. The state presented basically their evidence during the first phase of this case when you found the defendant guilty. However, and I suggest to you that they're part of the evidence that has been established that you made a decision to find the defendant guilty in this case. But now you have had an opportunity to find out a lot other factors and circumstances that I suggest to you in this particular case that a life sentence is the appropriate vote. Now, I told you in opening statements that I expected that you would find out a lot more about Mr. Ritchie and mitigating circumstances for your consideration. As you were told during opening statements, and I believe that has been established by various factors, Mr. Ritchie was born and raised in Jamaica. He was subjected to a very difficult childhood, and that he was subjected to physical and emotional abuse while growing up, and that he was raised in an extremely high crime section of Kingston, the nation's capital. And there may be some dispute when you heard the testimony of Ms. Ridley as to what was considered a high crime area back then versus now. But I suggest to you that if you remember that she was very apprehensive when confronted or asked about crime, high crime statistics. I suggest to you that while growing up, it's clear from the testimony that you heard from Dr. Eisenstein interviewing witnesses, as well as the video itself, that Mr. Ritchie was in fact grew up in a high crime, poverty-stricken area. And ironically, despite this, and we'll get more into this in a few minutes, Mr. Ritchie, prior to you finding him guilty of this case, he has no prior felony convictions. I told you that you would see a video in Jamaica, filmed in Jamaica, where you would hear from several people that testified, as you saw the video itself, that you saw a chance to see the area that Mr. Ritchie grew up in. It's certainly not a wealthy neighborhood. And you heard about several people telling you not only about what the redeeming qualities that Mr. Ritchie had, but also of the fact that it was a crime-ridden area. There may be opinions as to what degree, but I suggest to you that that's been established. And they talked about Mr. Ritchie's childhood and him as a person. You also heard not only from them, but interviews that Dr. Eisenstein made in addition to speaking to Mr. Ritchie, that there was evidence of head injuries that he had suffered, partly in his childhood and partly as an adult riding motorcycles. And that's where, and I mentioned that you would hear about this during opening statements, that's where we went a step further, not just ignoring the fact that there was this information about head injuries, but that you would hear from two experts that would provide information and evidence about Mr. Ritchie's mental state. First, the neuropsychologist, Dr. Hyman Eisenstein, who examined him, and not only examined him, interviewed him at great length on many different occasions, and that led to the ultimate referral to the PET scans and the MRIs that Dr. Wu testified about. That you would hear in opening statements, I mentioned that I expected that you would hear evidence about brain abnormalities. Now, and then finally I mentioned to you that you would hear from for lack of a better term, a prison expert, Mr. Aubrey Land, who would testify about prison life and Mr. Ritchie's adaptability to serving a life sentence. Now, anything that I say in my closing arguments, I want you to fully understand that I'm in no way minimizing what happened to this little girl. But as I asked Dr. Downs, there are very few homicides, very few murders that involve no pain and suffering. There are some, I guess, if you get a shot to the head and die instantly, but I would suggest to you that most murders involve, by the very terrible nature of the murders, involve a certain amount of pain and suffering. Again, I don't suggest to you, I don't mention this in any way to minimize what happened to this young girl, but it's when you're evaluating all the circumstances, I think it's important to keep that in mind. Keep in mind that the death penalty should be applied very, very selectively. I suggest to you that it should only be given to the worst of the worst crimes, the worst of the worst situations, not just crimes, but knowing all about it, such as people that are repeat violent offenders.
Objection, Your Honor. There's a limiting motion about this.
All right, state the objection.
Okay.
As to that phrase.
We'll talk about the mitigating circumstances in a minute, and I just referred to that a minute ago. When I suggest to you that the death penalty should only be given to the worst of the worst, and it's important to keep in mind that regardless of what your vote is, Mr. Ritchie will be severely punished. There's no parole in a life sentence in the state of Florida. He will be, regardless of your vote, he will leave Florida State Prison in a coffin. He either is going to die by natural causes or by the death penalty. So it's not a situation where by voting for a life sentence that somehow Mr. Ritchie is not going to be punished. He's going to be severely punished regardless. But again, my suggestion to you is the death penalty should only be given to someone who has all of the categories of worst of the worst. Now, let's talk about the mitigating evidence that was presented. I'm going to talk first about Mr. Land. I think he was the second witness, but I'd like to go with him first because then we'll talk about the two doctors. Mr. Land is an experienced law enforcement or former law enforcement officer, former corrections officer who has a wealth of experience and knowledge about what prison life is going to be, and also evaluating people for purposes of whether or not he believes that that person can follow the rules and adjust to prison life. Mr. Land testified about his experience, about his qualifications, and was qualified as a prison expert, and told you about what prison life really is. It's not fun. It's obviously there's a lot of rules to be followed, and very limited as far as privileges are concerned. He evaluated Mr. Ritchie and indicated that, in his opinion, Mr. Ritchie is the type of person who has a low risk of recidivism and would, in his opinion, would be someone who would follow the rules and adjust to life in prison. You also then heard from the two doctors, and keep in mind, the first doctor, Dr. Hyman Eisenstein, is a licensed psychologist. He goes into the jail, as he indicated. I think he saw Mr. Ritchie on 8 separate occasions with a total of something like 32 hours where he actually spent with Mr. Ritchie. He did extensive testing. You heard, I don't have the list in front of me, but you heard a series of tests, multiple tests that he conducted over a lengthy period of time. The tests were to know a lot about Mr. Ritchie, his IQ, his ability to comprehend and make certain adjustments. You heard that the IQ test was very low. That's uncontroverted as far as any psychological testing, because no one else gave Mr. Ritchie a psychological test for IQ. There was also tests done for determine whether or not Mr. Ritchie is faking. Dr. Eisenstein indicated that, and for that matter, so did pretty much Dr. Lazaro, that Mr. Ritchie was cooperative, but you always have to double check for the possibility that a person that's being tested is doing something to try to make himself look crazy or retarded or mentally challenged or anything of that nature, that there are tests to try to determine whether or not faking is concerned. And clearly, Dr. Eisenstein performed several tests and indicated that there was no faking involved from his analysis. And in addition to just talking to Mr. Ritchie, Dr. Eisenstein reviewed records that were provided that he was able to get his hands on. Some records were just not available. And he also talked to family members. He talked to Mr. Ritchie's mother as well as a couple of other people. Plus, he had other information about not only the video, but other information that had been provided to him or to someone else regarding Mr. Ritchie. And based on that, not just because the suggestion by the state seems to be that just because the defendant said, I had a head injury, that, okay, that's enough to go forward with further testing. Everything that Dr. Eisenstein did before he recommended a PET scan and an MRI was a combination of full investigation, 32 hours of testing and interviewing Mr. Ritchie, but also talking to other people and looking at other records. So although he's not a medical doctor and cannot conduct these tests, he felt that there was sufficient information, sufficient indications that and he had come to, at that point, to a preliminary conclusion that there was, in fact, frontal lobal damage, that there was brain abnormalities, that there was evidence of brain damage. But you just don't go with what he says. He's the first one to indicate that, well, okay, I've come to this opinion, but I need some further confirmation. So then, before this ever gets to the testing and Dr. Wu, there's a neurologist that goes to see Mr. Ritchie at the jail and does further examination, and he's the one that prescribes the PET scan and the MRIs. And then the testing is done after a medical doctor or a neurologist has actually provided a prescription for these tests. So it's like, as we were talking about it earlier, it's not a matter of, well, let's just have a test just for the fun of it. There has to be a basis for getting that far. And then we get to the point where the tests are conducted and they are submitted to another doctor, which is, of course, Dr. Wu. Now, the state has made every effort to try to discredit Dr. Wu, but keep in mind, just like Dr. Eisenstein is a licensed psychologist, a licensed neuropsychologist, and has testified many times in courts of law as an expert in neuropsychology. Dr. Wu is also a licensed expert on neuropsychiatry, and he has testified many, many times in a court of law as an expert in neuropsychiatry. He then gets the test results. He doesn't perform the test. He simply gets the test results. And as you saw, he provided not only visual evidence that he testified to, but he also testified about his findings. And as he indicated, his findings were consistent, and I think his words was fit like a glove. So it's a combination of several multiple things that are leading to the mitigating circumstances, the mental mitigating circumstances. It's not just one doctor. It's not just one psychological test. It's a series of 32 hours of testing and interviewing, followed by another doctor prescribing the tests, the brain test, the PET scan, and the MRIs, and then finally having those results reviewed by another expert. Now, when comparing the different doctors that testified, and always keep in mind that this evidence is being presented to you with the understanding, and we've told you, and the judge is going to tell you, this information for you to consider it as a mitigating circumstance only has to be proven by the greater weight of the evidence, and more likely than not. So it's not a matter because the state presented a doctor that disagrees with Dr. Wu, that somehow means that it wasn't proven beyond a reasonable doubt, because I suggest to you that that's not the law. The law is that any mental mitigator that is being presented to you for your evaluation only has to be proven by the greater weight of the evidence, or as we've said, more likely than not. Dr. Eisenstein the state called Dr. Lazaro to refute Dr. Eisenstein. And ultimately, Dr. Holder testified to refute the testimony of Dr. Wu. Please keep in mind that even though Dr. Lazaro was called to refute Dr. Eisenstein, They are two different types of doctors. One, Dr. Lazaro is a psychiatrist. Dr. Eisenstein is a psychologist. They do different things. Dr. Eisenstein, number one, spent a heck of a lot more time with Mr. Ritchie. He did a lot of evaluating, testing, and developed his opinion over an extensive period of time. And then, before saying my final conclusion, I think we should do some additional testing, which I've already talked about. Dr. Lazaro is a psychiatrist. She did not do any kind of psychological testing. She basically sat and talked to the defendant for approximately 3 hours. Now, her opinion is basically that she wouldn't even follow up with any kind of PET scan or MRI based on her evaluation. I suggest to you that that's an incomplete analysis. But why not try to make sure that everything is followed up with and have further testing so that we know exactly what's going on? Dr. Wu and Dr. Holder are both respected doctors. They obviously have a difference of opinion, but keep in mind that Dr. Wu had not only access to Dr. Eisenstein's report that talked about these head injuries, but he made his analysis based on the test results that he had been provided regarding the PET scan and the MRI. Dr. Holder cannot say, he testified that he doesn't believe, despite the fact that Dr. Wu had presented data and reports that support that type of testing, Dr. Holder was saying that he didn't believe in that, but he was not disputing that the defendant may have suffered head injuries. He didn't do any kind of testing of the defendant and was not a party to any kind of interviews of the defendant or any kind of exploring as to what had happened actually regarding these different injuries that Mr. Ritchie suffered during the course of his lifetime. He's not disputing head injuries. Be clear on that. He simply is saying that he doesn't believe in the results that Dr. Wu came from examining the test results. Ladies and gentlemen, Dr. Eisenstein and Dr. Wu both support the mental mitigators that we'll talk about in a minute. One of the things that I suggest to you it should be given tremendous weight is the first mental mitigator, and that is the fact that the defendant has no significant history of criminal activity. In fact, he has no prior convictions prior to this case. Dr. Lazaro is saying that he has antisocial personality disorder. Now, for your consideration, isn't it strange that a 40-year-old man with antisocial personality disorder, which would make him a dangerous individual, that prior to this offense had no prior criminal convictions? I suggest to you that is and it's also inconsistent with the analysis and evaluation by Dr. Eisenstein, but also by Aubrey Land. They both testified that they interviewed him, they spent time with him, particularly Dr. Eisenstein, and that his personality is someone who is very timid, is not someone who appears to be constantly causing trouble, and it would be inconsistent with antisocial personality disorder that Dr. Lazaro concluded by simply talking to him for about 3 hours. And by the way, those 3 hours were not contentious. It was not a situation where Mr. Ritchie showed any signs of aggressive behavior. In fact, she said he was cooperative. Maybe he was slow in responding, but he was cooperative. I suggest to you that Dr. Lazaro is predisposed. She's basically someone who makes a lot of money being hired repeatedly by the state of Florida to testify in these kinds of cases. And as she indicated, I don't know if she said 100% or 99% that she's always testified as a state expert. She has never come to the conclusion in these kinds of cases where she agrees. She may agree on some small factors, but she has never testified, or she indicated she's never had a situation where she's evaluated a defendant and said, well, you know what, the defense expert has there's some validity to what the defense expert is saying. She's a qualified psychiatrist. I'm not questioning that. I am questioning her predisposition. By the way, going back to the video, because I think we brought that out earlier in one of the questions that I asked, but I want to make sure that everyone understands, if you have any doubt, that in the video there is some reference to someone named Trevor being violent or things of that nature. That is the defendant's, even though at times Mr. Ritchie has been referred to as Trevor, that reference in the video is the defendant's father, not the defendant. I just want to make sure that that's clear. Now let's talk about the mitigating factors that have been presented for your consideration. I've talked about some of them, but I want to go back to them. The first mitigating circumstance for your consideration that, again, only has to be proven by the greater weight of the evidence, or more likely than not, but this one is 100%. The first one is it's not subject to debate, it's 100%. Mr. Ritchie has no significant history of prior criminal activity, and in fact it came out during the evidence that the defendant has no prior criminal history. The second one is the first-degree murder was committed while Granville Ritchie was under the influence of extreme mental or emotional disturbance. I believe the state said that there was no evidence presented, and I would submit to you that that's not true, that Dr. Eisenstein was asked that specific question and said yes, in his opinion, it was committed while Mr. Ritchie was under the influence of extreme mental or emotional disturbance. And I'm trying not to be repetitious, and I apologize, but his opinion is not just based on a quick survey, a quick interview, and saying, oh, yeah, there's emotional disturbance. This was based on an extensive period of time, over a lengthy period of time. There was, I think, 8 occasions, 32 hours, but it was not back to back to back. It was over a period of time, and in addition to looking at other records and talking to other people. The next one is the capacity of Granville Ritchie to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. Again, Dr. Eisenstein was asked that specific question, and in his expert opinion indicated that yes, in his opinion, the capacity of Mr. Ritchie to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired, based on extensive research and investigation into this case, including the time with the defendant. The next one is Granville Ritchie suffered a significant head injury as a child, but received no medication and has continued to have migraines afterwards. No records could be presented, but it was not something that Mr. that Dr. Eisenstein opined simply by talking to the defendant. It was included in looking or talking to other people that substantiated that. And of course, we know about the additional matters regarding the motorcycle accidents that he had later on. The next one is Granville Ritchie suffered mental and physical abuse by his father, and Granville Ritchie's father was often absent because of 4 different families. I think that the evidence is clear that Mr. Ritchie's father was maybe not Father of the Year. He was mentally and physically abusive, and had several, I guess you could say, a womanizer. He had several different families. That's why, and I don't want to jump because I'm trying to follow the list that the jury instruction says, but he's the oldest of 18 siblings, and he helped raise them. And they're not all his full brothers and sisters, because apparently Mr. Ritchie Sr., the father, had 4 different families, including the one that Mr. Ritchie was a part of. Also, Granville Ritchie was raised in a poverty-stricken and violent neighborhood in Kingston, Jamaica. I know we got into a debate about crime statistics, and Miss Ridley had a different opinion of the crimes that she observed, but we couldn't really get very far with the crime rate statistics. And keep in mind, she works for the state attorney's office, and Mr. Ritchie was abused, and at 16 fled to the United States to avoid the beating and the environment that he was in. And you've seen the video yourself. It doesn't clearly show all the violence that happens in that section of Kingston, Jamaica, but I suggest to you that sufficient evidence has been presented to establish that mitigating factor. Granville Ritchie was kind and generous to others and possesses other positive redeeming qualities. You heard the people in the video talking about Mr. Ritchie, and the fact that he did bring back or send money to his family when he was working. And again, another factor is that he was gainfully employed at various jobs, such as working at Kingston Airport at a very young age, and also at Contrans Communication, making cell phone towers. And then finally, the fact that Mr. Ritchie has a low risk of recidivism based not just on the testimony of Mr. Land, but also of Dr. Eisenstein. The mitigating factors, the state has presented evidence to refute, and there's a bunch of different opinions being bantered back and forth. But again, for your consideration, if you believe it's been established that it's more likely than not that it is established, I would suggest to you that those are serious mitigating factors that should be considered by you. And we're talking not just about information that was provided by Mr. Ritchie and his family, but actual psychological testing by Dr. Eisenstein and by actual tests that exist. These are tests that are prescribed by a neurologist, PET scan of the brain and MRIs of the brain. These are tests that are done for that purpose, and they are tests that were interpreted by you, by an expert in that field, which is Dr. Wu. And again, I stress to you that you've heard Dr. Lazaro say that this is a man who suffers from antisocial personality disorder, but this is a man who, prior to this incident, had no record and had shown all these redeeming qualities that we've talked about. those factors, ladies and gentlemen, should be given tremendous consideration. It's not in any way minimizing the charges that he's been convicted of. I'm not doing that. But there are certain types of situations, certain types of individuals, and certain types of murders that are worse than in this situation. And I suggest to you that the death penalty should be limited to only those kinds of cases. It's not a situation where Mr. Ritchie is getting a slap in the hand. If you vote for life, and I ask that you do so, that he will be severely punished, living in prison, maybe in a very dangerous situation with people knowing the charges that he's been convicted of. Ladies and gentlemen, nothing that I have presented to you in the form of mitigation, including mental mitigation, is not a defense. This mental evidence is not presented to justify what happened. It's not an insanity case where that's the argument. This mental mitigation is for your consideration to see that this is not a case that should have the death penalty. Ladies and gentlemen of the jury, I know it's late, and I can't help but want to keep talking because it's so important that I want to make sure that I establish all of these mental mitigators. I submit to you that all of these mitigating circumstances warrants, or the appropriate sentence in this case is that Mr. Ritchie be given a life sentence. Accordingly, I ask that you vote for life. Thank you.